before I get into today's stuff, just a couple of things for those of you in Philosophy 205. Your reaction essays are due today. A couple of you have already spoken to me about having a problem with that. If you have a problem with that, come talk to me or Catherine afterwards. For those of you who did do them, please send them to the middle aisle and we'll funnel them in Catherine's direction. That's one thing. The other thing is, if you haven't yet done it, please remember that you need to complete the end of semester assessment in order to pass that class. So if you want to pass, do that. That's my best advice to you. Okay, so this is a special week for us. You guys with me? It's a special week for us. As you know, we have been bringing in this semester not only internationally renowned scholars, activists, practitioners, but also we're featuring work done here at SSU. And I wanted to finish the semester by honoring the winners of the Fall 2014 Warren Court Prize competition. And I'll say more about it in a moment, but let me just remind you all that if you want to learn more about studying ethics or justice or law here at Sonoma State, there's a lot of great stuff happening. This prize is sort of one of the new crown jewels in that effort, and I hope you'll come talk to me. I can point you to a lot of resources on campus if this is something you're interested in. So don't be shy. Send me an email. Come visit. There's exciting things happening. So the prize itself. Earl Warren, for those of you who don't know, was the 14th Chief Justice of the Supreme Court of the United States, after many other accomplishments. And that court, the Warren Court, was known for its important role in promoting liberty and justice. Some famous cases include Brown versus Board of Education, the Miranda case, the list goes on and on. And this prize has been set up to honor SSU students who produce an excellent essay on matters of ethics, justice, civil liberties, or constitutional law. So that's the sort of umbrella of areas covered by this prize. And this year we had a really impressive set of submissions. The topics range from constitutional law interpretation to paternalism, to racism, to euthanasia, to voter ID laws, and private property. A really impressive set of issues that our students are grappling with here. And the winners, as you'll see, came up with a lot of interesting arguments, and the three of us who were judges, Eric Williams, who's right over here from Criminology and Criminal Justice Studies, and John Sullins, who is not here right now, from Philosophy, and I were the three judges, and we had an unusual situation, and we ended up settling on two co-winners for first place rather than a first and a second place, because the top two papers clearly had very strong merits, but they were of such different qualities that it was hard to choose one to put on top. So it was a really nice set of submissions this year. Before we get to the actual essays, and they'll come up and say a few words about, the winners will come up and say a few words about their arguments. I want to also take a moment to thank Dr. Ken Marcus, who we're privileged to have sitting right over here today. Dr. Marcus, for those of you who don't know, and he'll maybe come up and say a few words a little bit later, he was a professor here for decades, first in the political science department, and then in the, it's a founding member actually, right? Founding member of the Criminology and Criminal Justice Studies department. And he has continued to stay involved with our students and helping them develop since his retirement. This competition is funded by a generous donation from him, and it's one of the really important ways that he has continued to inspire our students, even in retirement, and that's sort of a model for the rest of us in the professor group, I think. So please, before we go any further, please join me in thanking Dr. Marcus for his donation. Okay, so let's get to the winners. We have two honorable mention prizes and two first place co-winners. The first honorable mention goes to Lauren Funaro. Lauren, you're an English major, right?
Yes.
Yes, so in English we have a bunch of different majors here, which is nice. To Lauren Funaro, who's an English major and who wrote an essay on euthanasia and physician-assisted suicide called To Die with Dignity. So Lauren, please come up and say a few words about your paper. And congratulations.
So first I'd like to apologize because I'm very out of breath. Parking is not my friend and I had to go over there, so I ran here. But I'm Lauren Finaro. I'm a fourth year here at Sonoma State, and I'd like to thank everyone here today for celebrating with us, and the judges for carefully examining our essays, and of course, Professor Ken Marcus for his generous donations, and which I will be purchasing my lunches for the rest of the week, so thank you. My essay was called To Die with Dignity, and it focused on the controversies surrounding physician-assisted suicide, or PAS, for the terminally ill. Very few states have passed the bill that would enable such treatment, claiming that it is either an immoral act that disregards the value of human life or an unethical misuse of a doctor's position and relationship with one's patient. My goal was to provide an insightful look into the intricacies involved in the Death with Dignity Act by discussing the vast array of differing perspectives related to the topic. Within this essay, I ultimately determined that for circumstances where a terminally ill patient is of a sound mind and has been presented with other medical options available to them, the use of euthanasia is an ethical practice that can allow for a higher quality of life at the time of death that preserves their own bodily rights. While I disputed a number of allegations, I want to discuss the ones that I felt were more substantial in relation to my case. First were the arguments of physicians Foley and Hendon. They claimed that a patient would only ever wish to use voluntary euthanasia if they were not given enough information regarding medical opportunities that would allow them to die naturally in relative comfort. The two also believed that having an option such as euthanasia would ultimately lead to neglectful lack of care in hospice systems. They wanted instead to focus on improving health care for the terminally ill. Corresponding with them, Dr. Leon R. Cass discussed the Hippocratic Oath sworn by physicians, which promotes the preservation of life. PAS, according to Cass, betrays this premise and is therefore unethical. Radicals supporting Cass's idea of sustaining life at all costs were quoted having said that complete sedation of the patient is morally preferable to physician-assisted suicide. In response first to Foley and Hendon's assertion, I researched the requirements made under the Death with Dignity Act in Oregon. Within this, I found that a patient is legally required to first consult her attending physician as well as a psychiatrist and the Oregon Health Authority when requesting euthanasia. This is meant to ensure that the patient is made aware of both the state of their illness and what other options there are available to them. This is also to inspect the patient's state of mind. A patient who is depressed or suicidal would be considered unfit to make a reasonable decision regarding euthanasia and would be denied their request. Also, after establishing that they would like to undergo the process, a patient has the ability to change their mind at any time and opt for another route. Relating to their argument about neglectful care, evidence has shown that the terminally ill who chose PAS were treated relatively similarly to those who had not requested the process. It was the fear of the inevitable loss of bodily functions and one's own mental state rather than poor medical care that was the ultimate deciding factor for most patients. While I agree that hospice systems should be improved, I do not think that the idea of medical advances is enough to completely extinguish use of physician-assisted suicide. It's improbable to claim that every physical ailment can be resolved through medicine, and because patients that are eligible for euthanasia must have either 6 months or less to live, such cases are faced with a quality of life that would be drastically reduced either due to their disease or life-prolonging medications. In response to those who would rather a sedated patient, I used their own supposed moral reasoning to discount their claim. If it is against their code to euthanize a patient who wishes it, then it should be so to forcefully reduce a patient's quality of life to something that is like death, where the ill person is unconscious and has no mobility. Concluding my essay, I remarked that the underlying issue of legalizing physician-assisted suicide is that of a person's right to determine their own quality of life and autonomy. While it is possible to dispute the morality of voluntary euthanasia, I believe that the patient should ultimately be granted the option to face such a decision. In these circumstances where the person is diagnosed with 6 months or less, and they have been provided with proper information, it is both the compassionate and politically ethical decision to allow them their natural right to live and die according to their wishes. As stated in the manifesto written by the former president of the World Federation of Right to Die Societies, Derek Humphrey, views on the dying process contrary to those expressed are respected, but must not trump the autonomy of the dying person's own decisions. Thank you.
Okay, our next honorable mention winner is Holly Brown, who is a criminology and criminal justice studies major, for a paper on constitutional interpretation entitled Theory of Constitutional Interpretation. Congratulations. Come on up.
Hi, everybody.
First, I'd like to say what an honor it is to be here today, but I'd also like to take a minute to recognize everyone that made this possible, starting with Dr. Ken Marcus for making this entire thing possible with such a generous donation, Professor Josh Glasgow, the Center of Ethics, Law, and Society for putting it on, as well as the judges, and also Professor Williams for encouraging me to enter my paper. So just a little bit about my paper. Like you said, it's about theories of constitutional interpretation. With 9 justices determining what a largely debated document means, there will no doubt be conflicts on how to read it. There are many pre-existing theories, however, in my opinion, there is not one that encompasses how to read the Constitution in its entirety. In studying and learning about different theories used, aspirationalism, also known as a notion of a living constitution, was a theory that stood out most to me. The theory realizes that the Constitution was written over 200 years ago, and the men who wrote it could not predict the future. They couldn't predict that we would have internet or airplanes or cell phones, and so therefore writing the Constitution obviously doesn't really fit with how our lives are lived today. It adapts with us. However, like I said before, I do not think that it can stand alone. There are many positives, but as is, it is a loose construction of a theory that leaves our Supreme Court with a lot of influence in making decisions. I pulled 2 other theories from the list of theories that we learned about, structuralism and textualism, to add to aspirationalism to create a new theory, what I called a strict notion of a living constitution. These 2 additional theories adds a restraint and gives the justices more guidelines on how to interpret the document. Structuralism believes that the court's job is to keep the government's branches in line. This would essentially make sure that the court is only taking and deciding cases within their jurisdiction. It would also keep the line between state and federal government rights clear. Textualism also adapts with the times, but it sticks close to the text of the Constitution. It is meant to help remind and keep justices reading the Constitution for what and why it was written in the first place. There will never be one theory that will be the correct theory interpreting the Constitution, and I believe that using multiple is the best option in keeping justices honest to the document and to the people. Aspirationalism comes close, but adding textualism and structuralism to keep them from coloring outside the lines was what I wrote to be the most beneficial theory, a strict notion of a living constitution. Thank you.
Okay, we now have our 2 co-winners of first prize. The first is also a major in the Criminology and Criminal Justice Studies Department, Monique Santana, for her paper, The Best Theory, also on Constitutional Interpretation, The Best Theory of Constitutional Interpretation, Aspirationalism. Congratulations.
Hi everyone, my name is Monique, and I just wanted to start off by saying a big thank you to Dr. Ken Marcus for making this whole thing possible for us. And I wanted to say thank you to Professor Glasgow and the other judges, and Professor Williams for supporting me through all of this and helping me out. So I wrote my essay on constitutional law, and just to give you guys, just to explain, there are several theories on constitutional law that the United States Supreme Court justices use when they interpret the Constitution and apply it to the cases that come before them. And the one that I felt was the best and that I based my whole argument on in my essay was aspirationalism. And the reason I chose that theory is because, in my opinion, it contains the most valuable notions. For example, when the justices apply this theory, it means that they are viewing the Constitution as a public text made for the people of the United States. And this theory also ensures that they consider the consequences, that their decisions will have on contemporary society. Kind of like Holly was saying, they apply the Constitution to all the different cases that have to do with now the internet or cell phones or the computer and all that stuff. So it's really important that they consider the consequences that their decisions are going to have. And it means that through their reasoning, they're going to be pragmatic. So this is also important because Supreme Court justices are not elected officials, yet they have the power to set precedent and, in a sense, make law that really affects every single person in this country. And we are a democratic society, so that is something that we really value. And most importantly, I chose this theory because it it values human dignity above all else. And I highlighted some different cases where the Supreme Court justices have expanded like civil rights and human rights and gay rights. For example, Brown v. Board of Education led to the eventual desegregation of the public schools, and Lawrence v. Texas paved the way for the expansion of gay rights. And because the Supreme Court justices have applied aspirationalism to those cases, they have really established many of the freedoms that we enjoy today.
Okay, our final winner, the second co-winner of first place. It's hard to get out. Is a philosophy major and someone that many of you know because it's the TA for Philosophy 205, as it turns out. And so it's Catherine Merrill for her paper, Moral Responsibility and Implicit Bias. Congratulations.
Okay, so first off, thank yous. I want to thank Dr. Ken Marcus for sponsoring this competition, and also the judges, Eric Williams, Josh Glasgow, and John Sullins. And I also want to thank Josh Glasgow and Julian Parker for just encouraging me to enter this competition, both last semester and this semester, and just for giving me encouragement and feedback in general. So it's appreciated. And so the original version of this essay I wrote for Josh's Philosophy of Race class, and one of the first things that we looked at in that class was a lot of empirical data on racial attitudes and some of their ramifications as far as limiting opportunities for those who are targets of some of the more negative racial attitudes, particularly people of color. And so the research I ended up focusing on in my paper actually indicates that people harbor a lot of sort of unconscious negative racial attitudes that are contrary to their explicit beliefs and attitudes. And so a lot of this research is being conducted via the implicit association test, and not to get too into the specifics of how the test works, but basically it's able to measure sort of these automatic, like split-second associations that people make. And these wouldn't ordinarily be like available to introspection or observation because they're just like they happen so quickly and so automatically. But what the test is revealing is that a lot of people that don't consider themselves to be racist nonetheless harbor these unconscious negative attitudes against specific races. And so the question I address in my paper is, are people morally responsible for such biases? And perhaps more importantly, are they responsible for the behavior that stems from it? And so for the original prompt for the essay that we had to write, we were asked to consider a hypothetical scenario. So there's a woman, she's the boss of a large company. She holds no ill will against Black people and believes people of all races should be treated equally, but she hasn't hired a single Black person in over 10 years. When she takes the implicit association test, the test reveals that she harbors a slight bias, implicit bias against Black people. And she's like totally horrified by this, and she changes her hiring behavior immediately and adopts a more equitable hiring practice. And so my question is she responsible? The question is she responsible for the hiring behavior up to the point of this revelation? And what I argue is that she is responsible for the behavior because while the implicit attitudes aren't directly available to introspection, her behavior is something she is capable of observing. And as someone in a position of power, she has a heightened responsibility to monitor her own behavior and change it if necessary. And there's a discrepancy between her behavior and her explicit attitudes and beliefs. She could have inferred the existence of her implicit biases to account for this discrepancy. And so any appeal to ignorance, I just don't think will work as an excuse. And then also, like, once she becomes aware of these implicit attitudes vis-a-vis monitoring her own behavior, she can make an effort to rid herself of them. And some of the research that we looked at actually shows that if people form an intention to rid themselves of their implicit biases, with the conviction in mind that racism is wrong in itself and not just socially unacceptable, that they are successful in doing so. And in the meantime, they can alter their behavior in spite of these implicit biases. And so, since people do have control over their behavior in this regard, I think they're morally responsible for it. And that's pretty much what I argue for.
So congratulations again to all the winners. I just want to emphasize the point of this competition is ultimately to spur excellence in writing on these important topics among our students. My personal hope, and I think the hope of many of us who teach here, is to see the quality of writing on these topics improve every single year. And I think we're seeing that, and it's just really inspiring to see what our students are doing. This is sort of one of my happiest days of the year in the job because I get to hand out cash prizes and recognize students for their excellent work. So congratulations again to everyone. One of the many topics covered by the prize is free speech. And I think, Ken, did you want to say a few words about speech here at SSU and the history of all of that? Welcome to Ken Marcus.
I had 30 years here, which was more than enough. But it was very exciting being here at the beginning, and where there were no rules and regulations, because I had come from Illinois State, which was the oldest institution in Illinois, and really rigid. And if you know, this is Adlai Stevenson. And Adlai Stevenson was born in Bloomington Normal, where Illinois State is. And it was dry. And the newspaper was the Daily Pantograph. So I have a close connection there. I went from being a bomb thrower, if you will, in Illinois State to, if you will, being a reactionary, if you will, here at Sonoma State. But anyways, Earl Warren, my whole career, 35 years of teaching, was really dominated by the Warren Court. And I remember when I was a graduate student for my PhD at Urbana-Champaign, we were waiting in June of 1954 for the decision by the Supreme Court on Brown versus Board of Education, because they had heard it the year before and they couldn't arrive at any decision. So we were all waiting to see what was going to happen. In the meantime, the Chief Justice, what was his name, Vincent, who was the Attorney General under Truman, had died in October of that year. And Frankfurter is supposed to have said he now believes in God, because Vincent was such a terrible Chief Justice, the court was all over itself. And so President Eisenhower appointed, and I think it was a recess appointment, he appointed Warren to become the new Chief Justice. Warren, if you remember, there was a battle for the Republican nomination between Taft and Eisenhower and Warren. Warren threw his ballots to Eisenhower, and Eisenhower then made him Chief Justice, and he rumored to have said it was the biggest damn mistake he ever made. But anyways, Warren became, of course, the Chief Justice over this court that was full of great personalities, unlike today where they're all coming from the Court of Appeals, and every Supreme Court justice either went to Harvard or Yale. In the current court, the court was much more diverse and so on, unfortunately. But anyways, that started my career. I went to Washington. I worked for 5 years working in the Navy Department. Then after I finished my PhD, I came back to Illinois State, and where I taught. And the Earl Warren decisions kept coming out. And you go down the cornfields in Illinois, great big signs, impeach Earl Warren, John Birch Society. And we'd be going through the decisions with my students, and I remember one of the decisions, no Bible reading in public schools, and one of my students came back from Cairo, Illinois, and said, the principal said, I don't give a damn what the Supreme Court says. There'll be that we're going to continue to read the Bible in the public schools. So, and then we came out here, my wife and I, in 67, and of course we continued with the Warren Court years. I just wanted to mention something, and that is, we had Mario Savio taught at Sonoma State for many years. And I think it's just the 40th anniversary that was recognized by Berkeley because of the free speech movement that he was involved in during the Vietnam protests and so on. students came out here and were sitting in this hall, and the students from San Francisco State said, "What are you letting them build San Quentin North up here for?" And of course, these early buildings were all designed pseudo Mussolini by the Department of Finance at that time. But anyways, Mario was an adjunct faculty in philosophy and mathematics, and he was, you know, one of the great leaders of the free speech movement. And to me, it's so ironic. You read the chancellor of Berkeley now says, "Oh, we're honoring Mario Savio now, the great, you know, free speech movement, but we have to be careful that we don't hurt people's feelings when we say free speech," which is, you know, just biggest bullshit I ever heard, if you will. And also this trigger warning. So we have to warn the students that they may be reading something that's unpleasant. I mean, to me, it's such an anathema to what we as college professors should be doing. We should be challenging you. We should be, if you will, making you stand up for what you believe in, not making you being comfortable. The role of a faculty member is to challenge the students. And what we have now really makes me very, very angry, because I'm really tend to be absolutist and free in terms of free speech. So we lost Mario Savio, and I think he would be turning over in his grave by the chancellor of Berkeley, who says, you know, we believe in free speech, but we have to be very careful that we don't make people feel badly by free speech. Free speech is supposed to make people, particularly college students, for Christ's sake, challenge what they believe in and so on. We also recently lost Bob Bell, who was, when I came here, he was one of the great defense attorneys and won several cases at the California Supreme Court about people who are not mentally competent. Martine Miller was the public defender here. I was deeply involved with friends outside at the prison. When I first came here, we had a lot of really interesting mavericks, if you will, who came to Sonoma State and Sonoma County. So I dedicate this to Mario Savio, who was a real friend of ours and a real believer in free speech. And I know our faculty are going to continue to fight for free speech, even against, if you will, the authoritarian bureaucrats who tend to govern the system. So congratulations to you, the winners, and congratulations to all of you to come to beautiful Sonoma State. It's really gorgeous now. If you don't look at Sonoma, at Ives Hall and Stevenson and Darwin, the rest of the campus is just beautiful. And it's a wonderful place, and enjoy it.
Thanks again, Ken. Okay, so for those of you in Philosophy 205, if you have any questions for me or Catherine, please let us know. Otherwise, that's going to wrap up the semester for us. I hope to see all of you studying ethics, justice, law, and so forth next semester, and don't be afraid to be in touch. And have a nice break.